Recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ms. Palante, for your presence here today as well as for your leadership. I think I want to pick up where my colleague left off and ask you about the recent IP or IBS versus Copyright Royalty Board case. I believe you're familiar with the case. You referenced it in your written testimony, correct?
Correct.
And the case involved a decision by the D.C. Circuit, I believe, that held that in promulgating copyright regulations, setting rates and terms, the Library of Congress is undoubtedly a component of the executive branch. Is that correct?
That's what the case says.
Now, there was already a complicated mix related to your structure as discussed during this hearing. How does this decision impact what was already a complicated situation? How do you interpret the decision, and what guidance can you provide to us as to how we should interpret the decision and what it means in terms of how we move forward?
Thank you. I think it's a fairly significant decision. On the one hand, it confirms that the Library of Congress is like no other agency in the federal government, in that it is a clearly hybrid agency. You've got the copyright functions clearly in the court's opinion, being executive branch in nature. And then you've got, for example, the Congressional Research Service, which can only be legislative in the same agency. And as I said earlier, I think you've got this position where the Librarian of Congress is really a kind of incredibly Herculean job, where you're running kind of library functions, legislative functions, and then also executive branch copyright functions. You're right that these issues are not new. One of the things that's very interesting to me is that from 1802 to 1897, the Librarian of Congress was not a Senate-confirmed position. It was when Congress in 1897 formalized the copyright system within the library that Congress, and it's very interesting to go back and read this, speaking about constitutional issues that have now popped up again, said these issues must be constitutionally correct. They must flow constitutionally, so the Librarian of Congress must be Senate-confirmed. The copyright system affects the legal rights, economic interest of those who rely on it.
Right. Well, the copyright system, in fact, or Congress's power to legislate copyright and intellectual property, indeed stems from Article 1, Section 8, Clause 8 of the United States Constitution, which is, I gather, the reason why Judiciary committees got jurisdiction over this very important area of law. Now, you mentioned in your testimony that that the agency finds itself in a situation where copyright issues have become increasingly complex, and at the same time, resources have become increasingly strained. Very difficult situation to be in. Could you clarify what has increased the complexity of the copyright landscape?
Well, the digital revolution has made it more complex. And so where people used to, in the chain of commerce, work with analog physical items, CDs and books and DVDs, they are now getting their content on mobile devices and digital platforms. And so copies may not be involved. It may or may not be a generational thing as well. I happen to have teenagers. They don't want to own anything. They just want access to it. So it's it's this real focus that on display and access and streaming, making the public performance right arguably more important in the future than the reproduction right and distribution rights have ever been. And so we have all of that kind of coming into the mix, and then that requires us in our registration system to also make those shifts. How do we examine a work that is really only made available to the public through streaming?
Now, given the increased complexity, as you've laid out, as and I think in a manner shared by a significant number of people in this institution, clearly, in my view, that suggests that we've got to look at providing the agency with the resources needed to deal with an increasingly complex landscape. But does the complexity also suggest, in your view, that it's reasonable for us to take a hard look at what an appropriate structure would be in the 21st century?
I think you have to, and I appreciate the question. I'll say it this way. A 21st century legal framework requires a 21st century agency, and the structure, the budget, the IT, the principal duties, the stature, all of those come into play as you look at the question, I think.
Thank you very much. I yield back.
Thank you.
Thank you.